Okay, this video is going to cover the basics, sources and classification of law. Um, from a historical perspective, law has come from three sources: natural law, which you have as being a person; divine law, which is basically from some divine book like the Bible or the Quran, and then positive law is man-made law. So American law is fairly complicated, but the foundation it's important to understand. We live in really a hybrid of a democracy where all power resides with the people, theoretically, and we live in what's called a constitution or a republic, which both citizens and elected representatives are bound by the U.S. Constitution, which is the supreme law of the land. All right, let's talk a little bit about the Declaration of Independence. The anniversary is coming up, but 1776, it's not law. I think that's the first thing to understand, but it's the foundation of American law. It does reference natural rights and divine law, which justified the colonies' separation from Britain, and specifically states, quote, to which the laws of nature and the nature of God entitle them. And as I said, it's not man-made. It's not positive law because but it's a blueprint, more or less, foundation for what we're going to talk about. What's especially important in the Declaration is a reference to unalienable rights, certain unalienable rights. These include life, liberty, and the pursuit of happiness. Now, my point is that life, liberty, and the pursuit of happiness is, you don't have a right to pursue happiness. I mean, it's got to be codified or in positive law. So let's talk about four sources of positive American law, and they are, and I'm going to just tell you what they are. They got the Constitution, which is a manifestation of people's will. Got statutes, which is a manifestation of legislative power that we're talking about on the federal level. Congress, the House and Senate, pass statutes. Those statutes have to be constitutional. So there's kind of a hierarchy here. Administrative law, this is a manifestation primarily of legislative power, although the executive has some has administrative power to create administrative law. These are rules. We also refer to administrative hearings before the agencies, the various administrative agencies on the federal, state, and local government. Then we have common law. These are court decisions. It's a manifestation of judicial power. And this is at the low end of the hierarchy. It can be altered by statutes and regulations. It's got to be consistent with the Constitution, all of that. But the important thing about common law is that court decisions and even court authority can be limited by statutes. I think that's very important. Common law goes back to Roman law, English common law, still very relevant because it provides a foundation of many of the areas of law we're going to talk about. So with respect to the Constitution, let me just say you can look at links to the Constitution. A good one is from the U.S. Constitution Center. They have the whole thing listed there, but it's set up like a business plan. There are three main articles. The legislative enumerates the power of the legislative branch. Again, that's Congress on a federal level. Remember, the U.S. Constitution, it's important to understand, was not the first iteration of a national government. It was that part of that, there were the Articles of Confederation, which uh, uh, was ratified in 1781, even though it was more or less proposed in 1776, ratified in 1781, didn't last very long, and the Constitution, as you know, it was ratified in 1787. I think the important thing to understand the federal Constitution is designed to limit federal power, and uh, and it does establish a system of checks and balances between the three branches, the legislative, executive, and judicial branches. So, um, so we take a look at there's 27 amendments to the U.S. Constitution. The big ones are the first 10, get referred to as the Bill of Rights. These were part of a bargain for the existing colonies to sign on to the new Constitution, because remember, there already existed these Articles of Confederation. So to get the 13 colonies to sign on, the deal was that there would be these first 10 amendments, which would guarantee certain, you can call them unalienable or natural rights or God-given rights to the people: free speech, freedom of press, right to be free from unreasonable searches and seizures, etc. And these, freedom of religion, for example, these all apply to natural persons and legal persons. When I say legal persons, I'm talking about corporations, businesses, stuff like that. The one of the articles that's super important is Article 6. It basically says the U.S. Constitution is the supreme law of the land. Every state, to be part of the United States, every state has a constitution that recognizes that fact. So that's an important deal. And no laws can violate, or no court decision, nothing can violate the U.S. Constitution. So as I noted here, it codifies some natural law and unalienable rights. Big Amendment, the 14th, which is a product of the Civil War, that basically applied to the states and incorporated. It's a vehicle to incorporate or apply most of the Bill of Rights to the states and protect the people in those states. So, so that's the big ones there: due process, equal protection, and as I said, incorporates most of the Bill of Rights. The important to understand that the Constitution, these these basic rights, civil liberties set forth in the Bill of Rights and the 14th Amendment, shield people, natural, legal, from the government, protects you from the government. So there's got to be some government action, some called state action, involved for you to claim that your constitutional rights are violated. If your neighbor is maybe spying on you or breaks in your house, that's not a constitutional issue unless your neighbor is a police officer or was acting for the police. But it's certainly a crime, and we'll talk about crimes or a civil wrong known as a tort. So let me just go over classifications of law here. It's important to understand there's kind of a parallel framework. There's federal, in the federal government, we have the U.S. Constitution, U.S. statutes, federal, the executive, administrative law, and federal courts. States have similar framework. So you got states have U.S. They have their constitutions, statutes, administrative law, in courts decisions, but ultimately they cannot violate the U.S. Constitution. Civil versus criminal, I'm going to talk about that in separate videos, but basically civil, someone suing you, they're looking for damages. Normally that's money, but it could also be what's called an equitable remedy. For example, we're going to study sales law. You may have bought something and not received it, and you just want the thing. You don't want your money back. Criminal, only the government prosecutes. Uh, uh, that's the issue. There is there are criminal statutes, and the government must prove every element of the crime defined by statute beyond a reasonable doubt. The risk there is loss of liberty, jail time. I should say in civil cases, the burden on the plaintiff is by a preponderance of the evidence. Substantive versus procedural law. Substantive defines the crime, for example. Procedure will tells you how you go through the process, arrest to trial, etc. Private versus public law, private law contracts, public law statutes. Important to understand that this issue of preemption, that a court, we're going to talk about the court's jurisdiction, and just like with common law can be preempted by a statute. So that's all cool. So that's the end of that explanation.